Good morning, everybody. Thank you for joining me for today's webinar. My name is Amber Hines, and I'm the owner of Ashbur, where we specialize in Medicaid compliant annuities, specifically short-term annuities that can't be found with other insurance carriers. And today we're going to be talking about gifting and annuity plans for individual clients that do not have a spouse and who have primarily non-IRA assets. And a second part of the webinar is going to be presented in October, and that's going to be where we have an individual client who has a lot of IRA assets and not a whole lot of non-qualified funds. And so I'm happy that everybody is here with us today, and you can find a copy of the handouts from today's webinar and the handouts portion of the GoToWebinar dashboard. And if you have any questions during today's presentation, feel free to type those into the questions tab of the GoToWebinar dashboard as well. Again, my name is Amber Hines, and I have almost 20 years of experience working with elder law and estate planning attorneys across the country to secure Medicaid compliant annuities for your clients. I'm insurance licensed across the country, and I hold a Series 65 license with FINRA as well. I created Ashbur to really assist advisors and attorneys across the country with pre-planning options such as hybrid long-term care insurance policies, and then also crisis planning, primarily by way of a Medicaid compliant annuity or a prepaid funeral plan if we have a small spend down amount that a client is looking to spend. Some of the ways that my company can help you and your clients is we offer complimentary case analysis. So we will help to determine the optimal amount to purchase an annuity with, the term of the annuity, and which assets your clients may consider annuitizing. This is going to be especially important when we have clients that have either existing life insurance policies or existing annuity policies, IRAs, that we're looking to convert from what Medicaid is going to consider an asset into a non-countable asset. So my office would be able to help with things like annuitizing an IRA in a way that is going to work for Medicaid. We can consider a 1035 tax-free exchange if your clients have existing life insurance or annuity policies that may have a low basis that we're looking to really plan in the most tax efficient way with those assets. And so if our office is sent a list of your clients' assets, their income, cost of care, things of that nature, we would put together a complimentary proposal for your clients and determine whether a Medicaid compliant annuity makes sense for them. There are certain situations where it just doesn't make sense based on maybe the client's age or the client's anticipated longevity, things of that nature. And if that's the case, then we will definitely tell you that we don't recommend an annuity purchase in that case. We're not going to recommend an annuity unless it makes sense for the client and it makes sense for the Medicaid plan that we're trying to implement. We offer assistance from the beginning to the end of a case. So we will provide complimentary quotes for your clients to consider the purchase of the annuity. We also offer help with getting the annuity funded, especially if we have existing accounts that we are looking to use to fund the annuity. It's going to be pretty easy to fund the annuity if your clients have money in checking, savings, a money market account. Those can really just be transfers directly from a checking or savings account into a Medicaid compliant annuity. But if we have an existing annuity or an IRA account that we're looking to move into a Medicaid compliant annuity, that can be a little bit more complicated. And so we will help with the funding, either doing a direct custodian to custodian transfer or a rollover if we're dealing with qualified funds. So that's something to consider as one of the services that we do offer. And then also we assist with the death claim process for any annuity that would be purchased through our office. If you have a client that purchases an annuity and they pass away during the term of the annuity, our office would reach out to the state Medicaid department, determine if there is a claim, assuming the state is listed as a beneficiary, and then we would assist with closing out that claim and getting the contingent beneficiaries paid out either as a lump sum or just continuing those payments. We work with A-rated insurance carriers and we offer top-notch customer service. So usually we're able to provide quotes or a proposal the same day that we are contacted. We actually have some instances where clients are in the office with the attorney and we're rerunning numbers and we get those numbers back to you very quickly. So if you have a question about how to work with us or some of the services that we offer, feel free to reach out to me after the webinar. When we have just an individual client that is applying for Medicaid, we don't have a spouse or what we would consider to be a community spouse that we're able to transfer assets to, which means that an individual client that does not have a spouse to transfer assets to is limited on the amount of assets that they're able to keep. In most states, the amount of assets that an individual that is applying for Medicaid is going to be able to keep is around $2,000. This does vary from state to state. There are some states that have a little bit higher resource allowance for an individual. Illinois is one of them. They allow an individual to keep around $17,500. Missouri is another one at around $5,900, but the most common amount that an individual client can keep in liquid countable assets is going to be around $2,000. When we're talking about the income limitation for an individual, we generally want to keep the Medicaid applicant's total income less than their cost of care. This usually is not a hard test to achieve, especially if we are working with somebody that is in a nursing home that is costing them $10,000 or $15,000 a month in out-of-pocket costs. They're normally going to have a limited income, maybe by way of Social Security, a pension. Sometimes we have clients that have a long-term care policy that we can still get onto Medicaid if they have a limited long-term care policy that's maybe only paying $50 a day or $100 a day. We can still put together a Medicaid plan for them because their total income is going to be less than their out-of-pocket cost of care. There are some states that are considered to be income cap states, and if you do live or practice in an income cap state, then generally the Medicaid applicant's income must be less than around $2,800 per month. And if you have a client that has more income than the $2,800 a month, then you will have to help them to establish a qualified income trust or a Miller trust in order to have the excess income flow through the Miller trust before it is used to pay the facility. So most of you are probably aware whether you practice in an income cap state or not, but if you have questions about that, feel free to reach out. Some other resources that are going to be considered protected or non-countable from a Medicaid qualification standpoint are going to be the primary residence for a Medicaid applicant, especially if they intend to return home. This usually is going to exempt the home from qualification status. It does not protect the home, though, from an estate recovery claim. And so we do have some situations where clients will be Medicaid eligible because the only asset that they have is their home, and then their home will sell once they're on Medicaid. And at that point, we would put together a gift and annuity strategy similar to what we're going to be talking about today as a way to protect some of the assets once the person does sell their home, because the home proceeds are not going to be protected from Medicaid once it's sold. Also, usually the Medicaid applicant is going to be able to retain a car or an automobile, their household goods and personal property, an irrevocable funeral trust or a burial trust. And then some states do also exempt the IRA for the Medicaid applicant if the IRA is in payout status and the person is of RMD age. So there are some states where we don't necessarily have to deal with the IRA if it is already an exempt asset that is owned by the Medicaid applicant. If your client does have excess assets, normally we're going to develop a Medicaid eligibility plan, which can include increasing or improving the value of non-countable assets. So we just talked about that the home, car, funeral trust, things of that nature are going to be considered exempt assets. And so if your client does have a need for doing home improvement projects or purchasing a new car, that's a way to spend down some of the client's assets before getting them onto Medicaid. Also, we can purchase prepaid burial policies, pay off credit cards, a mortgage, or other debt. This would also include any type of legal fees that are paid in order to assist the client with the Medicaid planning process. So that's part of the spend down process as well. And then finally, if you have a client that has excess assets after all of those items are considered, then we would consider purchasing a Medicaid compliant annuity that's going to comply with the Deficit Reduction Act of 2005. And what that really looks like is that the Medicaid annuity has to be a single premium immediate annuity, meaning that the annuity is in payout status and it is only providing income to the client. It could never be a deferred annuity that is considered to be a lump sum of assets or a lump sum of cash that the client can go to the insurance company and request a surrender value or the cash value out of the contract. So a deferred annuity is going to be an asset for Medicaid, whereas a single premium immediate annuity, since it is only income and we can not go to the insurance company and request a refund of the or withdrawal other than the monthly payments from the contract, then the immediate annuity is going to be the only type of contract that is going to work from a Medicaid standpoint. An immediate annuity is a contract that would be purchased from an insurance company that is basically used to convert a lump sum of money into an income stream. So if the client puts in, say, $100,000 into an immediate annuity, that immediate annuity is going to start making payments back to the client usually the next month. So if they purchase in September, the immediate annuity is going to start providing income to them in the month of October, although we can delay that payment up to 1 year from the contract effective date. The most common planning strategy is going to be that the payment is going to be made the following month that the annuity is purchased. As a result of the Deficit Reduction Act of 2005, immediate annuities must meet strict requirements, which we're going to go through on the next slide. And there are very few insurance companies out there that offer Medicaid compliant annuities. There's hundreds of insurance companies out there that offer just an immediate annuity, but there's less than 10 currently that offer a Medicaid compliant contract, and even less of those 10 companies are going to offer a short-term contract. So it's something to be aware of if you are working with a client's existing financial advisor that's saying, yes, I can get access to a Medicaid compliant annuity, because you'll want to make sure that it has all of the language that's necessary from a Medicaid standpoint. But then also we're limited with some of the larger insurance companies as far as the term of the annuity that they can offer. They may say that their minimum term is 5 years or 10 years with the larger insurance companies. So you really have to do your research on which companies are going to allow what type of payment structure, and then also the language that would be contained within the immediate annuity contract to make sure that it's going to meet the Medicaid standards. The language that we would be looking for within a properly structured immediate annuity is that the contract is completely irrevocable, meaning that we can't change any aspect of the contract after the annuity is purchased and the client is outside of the right to cancel period. So we would not be able to change the annuity owner, the payee, annuitant, the payment date, the payment amount, who the beneficiary is. So the contract is going to be completely irrevocable in all aspects, whereas an immediate annuity that is not necessarily considered to be irrevocable is just going to be irrevocable with regards to the payment stream. So once an annuity is annuitized, we can't change the payment amount because it's no longer a lump sum of money. But a Medicaid compliant annuity has to be irrevocable as far as the parties to the annuity contract as well. The annuity must also be non-assignable, meaning that we would not be able to assign the ownership interest or the income stream to a company like JG Wentworth or Peachtree, companies on the secondary annuity market that would buy immediate annuities or buy structured settlements from clients for a lump sum of cash. So you would also be looking for non-assignable language within the annuity contract to make sure that it's going to meet the Medicaid standards. Another requirement of a Medicaid compliant annuity is that the contract must be making equal payments without any type of balloon structure at the end of the annuity and without any cost of living adjustment to the annuity payments as well. The actuarially sound requirement means that the client must be receiving their total amount that they put into the annuity within their Medicaid life expectancy. And so they're in pretty much all states other than two, Washington and Oregon, those are the only two that have an actuarially sound requirement that require the annuity to pay out within like 12 months of the person's life expectancy. Every other state, we are able to do a shorter term annuity as long as the annuity is going to meet the requirement of returning the original investment amount within the person's Medicaid life expectancy. The final requirement is that the state must be listed as a remainder beneficiary to the extent that they provide Medicaid benefits on behalf of the Medicaid applicant. And so there are a couple of exceptions to this rule if we do have a minor or disabled child, or if we are dealing with a married couple. There are some states where the spouse can be listed as a primary beneficiary before the state Medicaid agency. The planning opportunities that involve a Medicaid compliant annuity when we have a single client without a spouse who is going to be seeking Medicaid eligibility really are two different planning options. The first is a gift and annuity plan, which is what we're going to be talking about today. And then there's also the ability to do a standalone Medicaid compliant annuity plan, where basically we get the person immediately onto Medicaid by spending down all of their assets, not making a gift. But this really only works from an economic standpoint if we have a client that has a very limited life expectancy. So today we're going to be focusing more on the gift and annuity plan because that's primarily what we are going to do in individual cases. We're going to look at a case study example of Mary. She is a single individual who is 80 years of age, and after living at home with dementia for years, she's now in need of nursing home care. Her family feels that she could live for another 5 years in this sort of supportive care environment. And she has total countable assets of around $235,000. This is all going to be after tax dollars, money that's sitting in checking, savings, money market accounts. This is not any retirement assets that we're dealing with in today's scenario. Mary has monthly income of around $2,000 from Social Security and a pension, and she's currently spending around $10,000 per month on her nursing home care. We arrived at a $210,000 spend down amount by taking the total assets that Mary has of $235,000, subtracting out around $10,000 for a prepaid funeral as one of our allowable spend down items. We also subtracted out around $12,000 for legal fees. This obviously may vary depending on the location of the country that you are in, and also the complexity of the case as far as the legal fees charged. We also subtracted around $1,500 for items spent on personal items for Mary in the nursing home. And then we also retained around $1,500 in her checking account. You may recall that she was able to keep $2,000 of assets, but we usually subtract anywhere from $200 to $500 as the amount that the person is going to keep as their resource allowance, just so that we're not right at the $2,000 asset limitation. So after we subtract all of those items from Mary's total assets of $235,000, we arrive at the remaining spend down amount of $210,000. First, we're going to determine how quickly Mary is depleting her assets by determining the shortfall on a monthly basis. So if she is currently spending $10,000 per month and we subtract out $2,000 that she has from her income sources, she is short around $8,000 per month from being able to meet her existing nursing home costs. And so when we subtract, or excuse me, divide the $8,000 shortfall from the amount of the spend down, $210,000, we determined that Mary is going to deplete all of her $210,000 spend down amount in just over 2 years or 26 months. And because Mary is anticipated to live for around 5 years, Mary's family wants to do some sort of planning and not just plan on depleting all of her assets within the 26-month time frame that she would deplete her assets if she does no planning at all. So instead, we're going to put together a gift and annuity plan for Mary, which is going to allow her to make an immediate gift or a wealth transfer to her intended beneficiaries. And a lot of people question this as far as Medicaid currently having a 5-year look back period or transfer penalty for gifting assets within the last 5 years. So we know that because Mary is going to be intentionally making a gift within the 5-year look back period, that there is going to be a private pay period that is incurred as a result of making a gift. And so we're intentionally going to trigger a penalty period and then allow Mary to qualify for Medicaid after the ineligibility period or the penalty period has been served that is associated to making the gift. So this would be an intentional gift that we're making, and then also we're going to be intentional in the term of the annuity that is purchased in order to cover that penalty period or the private pay period. As a result of the Deficit Reduction Act of 2005, in order to start a Medicaid penalty period, the Medicaid applicant must be income and asset eligible, meaning that the person must be spent down to $2,000 or less in assets, and then also their income must be less than their cost of care or must be less than the income limitation in order to establish that that person is eligible for Medicaid, but for the fact that they have made this gift. If you are in an income cap state, again, if the person's income is greater than the $2,800, you would have to establish that qualified income trust in order to establish that the person is eligible from an income standpoint as well. I like to think of the spend down amount of the $210,000 going into one of the 3 buckets that you're seeing on the screen. So Mary's going to keep around $1,500 of assets in her name, and then she's going to make a gift, which is another one of the buckets. And then the final bucket would be that she would purchase a Medicaid compliant annuity, so that when the gift and the annuity are purchased, then Mary would be left with the limited assets of $1,500 left in her name. So the first step is to establish the income shortfall, which we've already done by taking the cost of care of $10,000, subtracting out monthly income of $2,000, and we arrive at the monthly shortfall of $8,000 per month. Next, we're going to determine the burn rate, and that is determined by taking the monthly income shortfall of $8,000, adding the divestment penalty divisor, which is a state-specific number that we have published on our website that would tell you the divisor amount. In this case, we're dealing with a Wisconsin case, so the divisor amount is around $9,600. And when we add those two numbers together, we're getting a burn rate of around $17,599 per month. And we get a lot of questions about what exactly the divisor is. And it really is a number that Medicaid is going to use to calculate the penalty period or the ineligibility period associated to making a gift. And so we're going to divide the gift amount by the penalty divisor in order to determine how long that person is going to privately pay for their care. The penalty divisor is a number that is considered to be a state-specific number that is based on the average cost of 1 month in a nursing home in your state. This can be more accurate in some states than others, and it will vary by region. And so if we have a client that is in the southern part of the country, usually the divisor is going to be lower than somebody that's in the northeast area of the country. And so it's really just used to determine how long the person is going to privately pay for their care. And again, you can find this number either on our website or within your state Medicaid manual or state updates that your state would publish on the different numbers within your state. The next step in developing the gift and annuity strategy would be to determine the length of the penalty period. And we're going to do that by taking the spend down amount of $210,000, dividing that by the burn rate that we calculated, taking the shortfall plus the divisor. And we determined that the term of this plan is going to be 11.93 months. We rounded that up to a 12-month plan so that our term of the plan of 12 months is also going to match the annuity period that we would be purchasing the annuity for. So next, we're going to figure out how much this client is able to gift out of the $210,000. And we do that by taking the term of the plan of 12 months and multiplying that by the divisor of the 9,600. And we determine that the immediate gift amount is going to be around $115,000. When we go back to the idea of the bucket method and determining how much is going to be used to purchase the annuity, we're going to take the total amount of assets of the total spend down amount of $210,000, subtract out how much we're going to gift of around $115,000, and we determine that we're going to purchase the annuity with $94,802. We're going to structure that annuity for a 12-month time frame because the annuity has to be structured for a whole number of months. We could not go to the insurance company and ask them to do an 11.93 month annuity because the annuity would not be meeting the equal payment structure, and it also just isn't feasible by an insurance company to do a fractional month of payments for the annuity. So the annuity is going to be structured for 12 months, and that's going to create a monthly payment of around $7,900. When we multiply the term of the annuity of 12 months times the monthly payout of $7,900, the total payout is going to be $94,860, which is a little bit more than the single premium amount used to purchase the annuity, which is intentional because there's a small amount of interest that would be paid on the annuity based on the rate of return that the insurance company would offer for a 12-month annuity. The parties to Mary's non-qualified Medicaid compliant annuity would be that Mary is going to be the annuity owner, the annuitant, and the payee. The state Medicaid department is most likely going to be the primary beneficiary to the extent that they provide Medicaid benefits on behalf of Mary. There would be the exception if there was a minor or a disabled child that they could be listed as a beneficiary before the state. That's not all that common in these scenarios if we have a single person, just because they could make a transfer to the minor or disabled child without a penalty. But that is an option if we do have a situation where there is a minor or disabled child to list them before the state. The secondary beneficiary is most likely going to be the kids, a trust, a charity, the person's estate, whoever they want to name as the secondary beneficiary after the state. During the ineligibility period, Mary's total income is going to be around $9,900 each month, and that was determined by taking her Social Security and pension of $2,000 that she had before we did any planning, and then adding the annuity income of $7,900 that we created by way of the annuity, so that her total income is $9,905. Her cost of care was $10,000 per month, and when we subtract out Mary's total income of $9,905 during the penalty period, her shortfall on a monthly basis is going to be $9,500. A lot of people ask us why we actually have a shortfall when it comes to the annuity purchase. Why wouldn't we just create exactly $8,000 per month of income that Mary would need by way of the annuity? And it really comes down to establishing that Mary is meeting the otherwise eligible for Medicaid criteria, where she has an income need and she also has a resource need, or she's meeting the income test and the asset test. So we generally are going to build in whatever amount of shortfall you would feel comfortable with within the plan. So we have some offices that request a $500 a month shortfall, and then we have other offices that want maybe like a $50 a month shortfall in the annuity payment, as far as how much income that we would be creating during that penalty period. The economic results of implementing the gift and annuity strategy is that Mary is ineligible for Medicaid for 12 months, which we know because Mary has intentionally made a gift of $115,000. During the private pay period, Mary is going to have monthly income of $9,905 in order to pay her nursing home, which is resulting in that monthly shortfall of $95 per month. And she's going to be eligible for Medicaid in month 13 after she would privately pay for her care through the first 12 months. The advantages of implementing this type of plan is that Mary was able to gift around $115,000 to her children, and this was more than the it was more than 50% of the $210,000. So a lot of people, when they're talking about half a loaf planning or reverse half a loaf planning for an individual client, they just assume that 50% is going to go to the gift and then the other 50% is going to go into the annuity, which is not an accurate statement, just because we have to consider the cost of care and also the amount of income that the client has. So if we have a client that has very high monthly income and their cost of care is not that much greater than what their income is, then we can make a much larger gift and we would only have to purchase a very small annuity to cover that difference between cost of care and the person's income. And so in this case, we were able to gift more than 50% of the assets, And because the gift was consisting of after-tax dollars, we're really not concerned about income tax consequences of making the gift, because the $210,000 was all money that was sitting in checking or savings. Mary is going to receive Medicaid in month 13, but the disadvantage of a gift and annuity strategy would be if we have a person that does have a limited life expectancy and we don't anticipate that person living through the 12 months of private pay or through the penalty period, that may sway us one way or another as far as whether we even recommend this type of planning, because Medicaid is not going to actually start paying for care until month 13. And so the family really wouldn't benefit from doing this type of planning, because they're going to be privately paying for their care during that private pay period anyways. So we would always be considering life expectancy when we are determining whether this type of planning would make sense for a client. If we assume that Mary passes away 6 months after the annuity is purchased and she's implemented the gift and annuity strategy, the state is most likely going to be the primary beneficiary, but only to the extent that Medicaid benefits are provided. And since the annuity is strictly providing income during the penalty period and Medicaid isn't paying the bill during that ineligibility period, if Mary does pass away, the state is not going to have a right to recover anything from the annuity. We would get a clearance letter from the state Medicaid department that basically says we didn't provide any Medicaid benefits to this client, and then we would help with getting the contingent or secondary beneficiaries paid out as quickly as possible, either in a one-time lump sum, or they would have the option to continue the payments if they wanted to do that. In the scenario where we have a client that is on Medicaid, they have a home and they sell the home, and they would use the home proceeds to do this type of planning, the state being listed as a beneficiary on that annuity is going to have an impact, because the person was on Medicaid, sold their home, and then did the annuity plan. So we have had certain situations where the Medicaid claim is going to exceed what is left in the annuity contract. And so in a case like that, the benefit of doing this planning is still that we're able to make the gift and preserve some of the home proceeds and get the person back on Medicaid if they would survive that resulting penalty period. If we assume that Mary passes away 13 months after the annuity is purchased, there wouldn't be any impact on the annuity contract at all, because the annuity was purchased for 12 months and she passed away in month 13. So there's not going to be any impact on the Medicaid compliant annuity contract. We wouldn't even need to contact the insurance company in that case to tell them that Mary passed, because they stopped making payments after the 12 months and the contract is considered to be exhausted and no longer in force. The time frame for implementing a gift and annuity strategy is really, we're looking for somebody that is already in a nursing home that is incurring costs that exceed their monthly income amount. So we would normally have that person who's already in a nursing home make a gift, purchase the annuity, and apply for Medicaid all in the same month. Once we do that and we would prove to Medicaid that this person has made a gift, they would calculate what the penalty period is associated to the gift by taking the gift and dividing that by the divisor. So we would obtain a penalty period determination from the Medicaid office. We would use the annuity payments to pay privately for the nursing home during the penalty period. And then once the penalty period is expired, the person would become Medicaid eligible after that. This is kind of just a calculation of how we would determine what the annuity amount and the gift amount is. So normally, just to summarize the steps that we went through, we would take the amount of countable assets that Mary had before we did any planning, the 235. We subtracted out funeral expenses, legal fees, personal items, and a resource allowance, and that's where we got the 210,000. And then from there, we took the 210,000 divided by the burn rate of the 17,599 and determined that our penalty period was going to be around a 12-month period. And we got the gift by taking the 12-month period, multiplying that by the divisor of the 95.99 per month, and calculated that gift of 115,000. And finally, we took the $115,000 gift and subtracted that from the spend down amount of 210,000 to get us to the annuity amount of 94,802, and we structured that over the 12-month period. So this is a calculation that our office is able to assist with if you have questions about how much a client is able to gift and how much would be needed to put into the annuity contract. You can reach out to us and we would be able to help with that type of calculation that your client would need to do. If you do have clients that own primarily retirement assets and they're of pretty significant value that you would not want to just have them liquidate the retirement account and make a gift, we are going to be discussing this planning opportunity in part 2 of our webinar. That's going to be the beginning of October. We're going to be talking about individual clients that have IRA accounts and what type of planning opportunities would be available for clients with IRAs or other retirement assets. And now it looks like I do have some time for questions. We have a couple here. Somebody is asking about the maximum monthly annuity payment amount that we would be able to offer. So there's not really a maximum amount of a monthly payment that we're able to offer. The insurance company that we work with doesn't put restrictions on the maximum amount of income. It really just depends on the client's needs, and in an individual case like this, the cost of care and the income would drive how much income we would be creating during that penalty period. But if you are referring to a married couple case and doing a very short annuity with a large sum of money, the insurance company that we work with doesn't put any restrictions on how much income we can create that way. But we, as a company, like to be reasonable in how much income we are creating, and not doing a $500,000 annuity over a 2-month period, because obviously that is potentially going to raise red flags with the Medicaid office. So if you have any further questions about that, you can feel free to reach out to me directly. There's a question here. It says, if the annuity is considered to be long-term, maybe 2 or 3 years, then how do we accommodate the increases in income over that time, keeping our clients' total income lower than their cost of care? Normally, if the client's cost of care or their income, increases with the cost of living adjustment, their cost of care is also going to increase during that same time period. But also in most states, as long as when we make the initial Medicaid application and we can establish that there is an income need when the initial application is filed, then the person would be considered to be otherwise eligible for Medicaid, and that penalty period, once it's established, is just going to continue to run anyways. But we do have some situations like if we're going to apply in the beginning of apply for Medicaid for the penalty period to start in February, and we know that February only has 28 days, we're going to structure the annuity payment to be slightly less than a 28-day month, just to be super cautious of the total income not exceeding their cost of care in that month. But normally, once the penalty period would be established and it is running by the state, then it's just going to continue to run even if the client's income does increase, if their Social Security or pension does increase during that time frame. There is a question here about, is the cost of purchasing the annuity included in the legal fees? In this case, we did not include the cost of the annuity purchase in with the legal fees. If you have questions about the cost for purchasing a short-term annuity, you can reach out to our office. Normally, the legal fees are going to be separate from a fee that we would charge. We charge an annuity processing fee if the annuity is going to be considered short-term or any time frame that would be 47 months or less, but our fees are based on the industry are lower than any of our competitors. So if you have questions about how much our fees are based on the annuity time frame and the annuity amount, feel free to reach out to me either by email or phone. Again, my contact information can be found on the screen here. My email is just my name, amber@ashbur.com, and our phone number is 888-441-1595. I want to thank everybody again for joining me today for today's webinar, and I hope to see most of you on our October webinar. We're going to have a guest presenter with me talking about retirement accounts and how to plan for an individual client that has large retirement accounts and how to plan with those instead of just liquidating them and gifting the retirement assets. Thank you again for joining me, and I hope that everybody enjoys the rest of their week.